Hello, everyone, and welcome to today's webinar. My name is Megan, and I'll be serving as today's moderator. We've partnered with Affinity HR to produce this session, and therefore we have a broad range of industries represented in the audience. We have representatives from building service management companies, wholesale lumber companies, vacation rental managers and owners, and many more. We've allotted time to address your questions at the end of the session. Throughout the presentation, you can submit questions through the Question tab on the GoToWebinar control bar. Please feel free to ask your questions at any time during the webcast. Today's session is being presented by Claudia St. John. Claudia is the president of Affinity HR Group. She's a human resource professional with more than 20 years in global human resources, employee benefit management, consulting, and communications. She specializes in strategic planning, employee engagement, organizational development, recruitment, and coaching. Claudia's colleague, Charlotte Jensen, will also be contributing. Charlotte has been in the HR field for nearly 25 years. Her extensive experience with both large publicly held companies and small privately held companies across numerous industries makes her uniquely qualified to bring forward-thinking HR solutions to today's business owner. At this time, I'd like to turn the call over to today's presenter, Claudia.
Great, thanks so much, Megan, and welcome all of you. I'm glad you're all here and excited to talk about workplace regulations. I know it's a scintillating topic and you can't wait to get to it. Just wanted to say a welcome to all of the associations and businesses that we do work with. We, Affinity HR Group, is an endorsed partner of many of the associations that are on the line, and so for them, we will probably be a familiar face. For the rest of you, we're delighted to have you on board, and I want to reiterate what Megan said earlier. We're going to be presenting a lot of information here. Normally, our webinars tend to be on a topic or on a specific go deep dive into a specific piece of legislation or regulation that's coming out. That's not what we're going to be doing here today. We're really kind of painting a portrait of a landscape of regulation that's likely to come down your way, or that you should be keeping an eye out. So as a result, we're going to be talking about a broad range of subject matters. As Megan said, we have a wide variety of business interests here as well. Some of these pieces are going to be relevant to some of you and some of them not, but we wanted to present the sort of the biggest hot topics that we know are there. And again, I just want to tell everybody that we are all in good company having Charlotte, my VP of Compliance, on the line with us, because she really is the brains behind the curtain when it comes to compliance, and she's the one who develops our employee handbooks and our policies and procedures. So I really, really encourage you, we're not going to stop in between the different content areas. So as we're presenting, if you have a question, just go ahead and ask it. We're going to cover all those questions, or as many as we can, at the end. Don't wait to the end to put your question in, because there's going to be more stuff coming on. And the other thing I'll say is that we have an offer, which at the end of the slide deck I'll put up. If you need some help or some assistance after this, one of our experts, Charlotte, or one of her team members, are offering a half-an-hour consultation for $75 on any of these topics or any other topics afterwards. So that's the total marketing pitch, but I just wanted to let you know that we are making that offer available to those of you who are here. Charlotte, are you there?
I am here.
Terrific. That's the lovely voice of Charlotte. So we're going to get into it, and the format basically is Charlotte and I will be sort of discussing all of this as we go along. So you'll be hearing from both of us throughout this session. What we're presenting to you is sort of what's coming down the line on a federal level, and what can you expect on the state level. Some of the trends and emerging regulatory issues that are happening, even at the most local of municipal levels, that are affecting our clients. When we start off and we're looking at the federal level, we really are looking at the Trump administration. There, to a large extent, until recently, it was really a process of reading tea leaves. We are beginning to see the beginnings of some real regulatory direction and guideline, and some policy papers that are kind of being floated out there. So we're beginning to see some solid stuff. But what we will be presenting to you for the federal administration standpoint is what we heard on the campaign trail, what we expect in terms of rhetoric, and if that rhetoric has been supported by anything since the Trump administration has taken hold. They now have a new Secretary of Labor. So what has he indicated as part of his confirmation hearings, and even some of the actions that the State Department of Labor has, Federal Department of Labor has taken place. So with that, we're going to start with at the federal level with the Trump administration. And the first order of business, which we knew it was going to be the first order of business, is the repeal of the Affordable Care Act, otherwise known as Obamacare. This has been a big issue for Republicans, and since they hold the House, the Senate, and the presidency, we expected this to be kind of a swift action. And it's been exciting even today. I mean, I was checking my my Twitter feed and listening to the radio just before I got on here to make sure I had the most recent information. Basically, the House passed a repeal and replace of the Affordable Care Act with its own version. It didn't pass the first time around, and then it did pass the second time around. It was sort of, it got mixed reviews. Not a lot of people loved it. Not a lot of comment around it, because the expectation was this was going to get kicked over into the Senate, and the Senate was going to do something dramatically different. And they'd promised that they were going to do something dramatically different. What they rolled out last week isn't as dramatically different from the House version as we had expected, and as a result, it's kind of having the same challenges that the House version had. And so what we see right now is they've got 5 Republican senators who've said that they can't vote for it for opposing reasons. We've got some who say it doesn't go far enough in truly repealing the Affordable Care Act. And then we've got more moderate Republican senators saying this goes too far, and we're worried about what it's going to mean for indigent care and the Medicaid population. So again, we've still got these ideological counterbalances going on in this debate, and we just heard right before we came on that they're not going to try for a vote before the 4th of July. So they will be still debating this when they come back after that recess. But what you need to know is that once we have a Senate version and a House version, then they have to go into reconciliation, and that reconciliation then has to be voted by both chambers again, and then it goes to the president's desk for signature. So what I would say is that for those of you who are wondering what this means for you, for the benefits that you're offering, I would say hold tight, because first of all, this has a long way to go before it's done to get through reconciliation. But the other thing is the insurance companies by law have to submit their benefit plans and their corresponding premiums to their related state insurance departments. That process has already taken place for 2018. So it's really unlikely that you're going to see any significant change in the marketplace for your own companies before 2019. So we've still got another year and a half under what we've already got is the best guess. Again, I think the best source of information for you as you're listening to these debates and listening to the policy discussions that are going on at the federal level is your broker. Because we get asked oftentimes, can you help us with our health insurance plan? The problem is these are state by state. It depends on what county you're in. It depends on what coverage you have. It depends on how many employees you have. It depends on how many are part-time versus full-time. It depends on their salary. So it really is a very complex area. And the people that still know the best for you are the ones that know you the best and know the market area in which you exist. So that's my spiel on the Affordable Care Act. Charlotte, do you have anything you would add to that?
Not on this one, since everything just kind of got a pause today, but I did have a client call me yesterday and ask, kind of in a panic, what do I do? They're talking about voting, and I had to be honest that there's so far to go that I'm not even doing a deep dive myself to see where it's at until it gets closer to the end point, because whatever it looks like today, and this is so true of many things that we're looking at, will so many ebbs and flows and will drastically change that until there's a signature, a passage and a signature, it's really hard to change your course.
And we've got some diametrically opposed perspectives on this issue within just the Republican Party. I mean, they're not planning on getting a single Democratic vote for this, but even within the Republican Party, it's tough. And I think you mentioned it, Charlotte, when we were talking about it the other day. It's tough to take something away once it's become, you know, an entitlement or something that people have gotten used to and rely on. So
exactly. Even when something feels like it's not quite right or broken, once it's out there, it's so much harder to roll back and undo and alter once people have come to count on certain elements. Yeah.
But they're going to try hard. That's something I'm sure is going to happen. They're going to try their hardest. Okay, so moving on. So this was the subject of actually 2 webinars that we conducted last year, which is the overtime provision. So a little bit of background on this. In 2015, Obama let it be known that they were planning on changing the standard underneath the Fair Labor Standards Act that regulates who can be considered exempt from the FLSA, the Fair Labor Standards Act. To be exempt from the FLSA means that you don't have to have all of your time tracked, and you get a salary and you do not get overtime. Currently, the standard as it is today and as it was when they rolled out that change, the income threshold is $23,660. So if you earn less today than $23,660, you cannot be considered an exempt employee. You have to be considered a non-exempt employee, which means that the Fair Labor Standard Act's provision for overtime and record keeping apply to you. What Obama rolled out was a change just in that economic threshold, which basically said that going forward, and it was to be effective December 1st, the new salary threshold was going to be $47,476. What happened was that people sort of scrambled because a lot of people had exempt employees between $23,000 and $47,000. So what to do? A lot of people made changes. A lot of people took a wait and see approach, and as December 1st rolled forward, we all thought, oh, here it comes, and then it stopped. 2 lawsuits were filed against it, and this was also after Trump had won the election, and so the Obama administration just sort of let it sit on the vine, and that's where it stands today. We haven't really heard much action on the Obama level changes that were put forward. The one change to that, however, is that we now have a Secretary of Labor, and Acosta, who is the new Secretary of Labor, did give some indication of what he was thinking about in his confirmation hearing. What he had said was that they weren't going to walk away from it entirely. He doesn't intend on defending, and because this is the Department of Labor, they would have to defend this change in law in the courts. They're not going to defend the size of the old threshold that was put forward, the $47,476. But he did articulate that he thought that a change is appropriate, that salary threshold is so low today that it's far below what the intent of the Fair Labor Standards Act was initially, and it hasn't been changed over time. So he did signal that he was open to a new change. That change, we've heard, is about $33,000 as the new limit. Not set in stone, but that's sort of the ballpark of what they're thinking of. So those of you who are on this call who didn't do anything before and have exempt employees who earn less than $33,000 should start paying attention to this. It means that if you have exempt employees under $33,000, you're either going to have to raise their salary up to that level, or you're going to have to revert them back to non-exempt, track their time, and give them time and a half. Our best advice on this is whatever you did before, if you rush to comply with the old Obama standard or with the new Obama standard, or you waited to see what was going to happen, wherever you are right now, hold tight. Don't make any changes until we really figure out what level it is, when it's happening. Just keep going as you know, carry forth. Charlotte, what do you think?
I would add a small asterisk to that even though at the federal level this number is kind of in holding right now, that some states are moving forward with increasing their salary threshold limit requirements directly. A lot of times it's tied to the state minimum wage, like to be salaried, you must be X times the state's minimum wage, that kind of thing. So my advice to folks is to not get so caught up in what's happening at the federal level that you ignore anything coming out of your own state on this, because for the first time, probably in a long time, maybe ever, we may have more states that have a different and higher standard than ultimately happens at the federal level. And as we'll always tell our clients, when you've got conflicting rules, you're going to have to go with the one that is the most generous to the employee.
Right.
So this may create quite a patchwork of what that magic number is based on where an individual is located.
And I would add to that you can kind of guess which states those are that are increasing those minimum salary thresholds. They tend to be the ones that are increasing significantly their minimum wages right now. You know, New York, New England, West Coast, California, Washington, Washington State, Oregon. So keep an eye, even some of the Midwestern states. Keep an eye on that, because you will you'll be likely to see that initiative rolled out as well. Okay, moving right along. So the new Secretary of Labor has taken a couple of issues. What we haven't seen this new administration, again, it's new. I mean, I think he's only been in there, what, 4 or 6 weeks. So not a lot of time to hit the ground running. But what we've seen them do is rolling back a lot of the more recent Obama interpretations and regulations that were put out. Those things that were kind of put through at the end that were administrative guidelines, those things are very easy to rescind and to take away. And so that's really what we've seen so far from this Department of Labor, is a lot of going back and saying, all right, what kind of regulations were put in place in the last, the last term of the Obama administration, and what can we easily undo? One of them was also guidance. Yeah. One other thing, I just want to actually go back, sorry, to this overtime provision. When we were talking with our clients, and we talked to a lot of clients in preparing for this, we found that a lot of them, even though they satisfied the income threshold for the to be considered exempt, there's also a duties threshold. You have to satisfy certain duties in order to be considered exempt. It's not just based on your salary, it's both of those together. And so we found that a lot of our clients, even though they were completely compliant from the salary threshold, they were not compliant when looking at the duties of those jobs. So I want you to write this down. If you have any question or think that you might have some misaligned employees, we want to Google Department of Labor DOL fact sheet, FACT, fact sheet number 17A, and that will give you all of the income threshold and the duties test that are necessary to determine whether or not somebody should be exempt or not. And if you need any help with that, give us a call. But that fact sheet should at least be the basis for which you would make that determination. Sorry, I completely forgot to mention that on that last slide. So it does actually get into this, which is that the Obama administration actually also in 2015 took a long look at what he saw was the emerging trend toward flexible work, joint work, and independent contractors. And the previous standard for independent contractors, and this is DOL fact sheet number 13, the standard which is used. Basically, that standard said that the individual has to be able to exert independence and control over their work to be considered an independent contractor. And that was really the standard, was the control test. Did they have and maintain control over the work, over their working hours, over accepting or rejecting work, over their pay, that sort of thing. Obama put in a new guidance that said it's not just that independence, it's how economically dependent is the independent contractor on that project work. And if that consultant or independent contractor is significantly economically dependent, then they are an employee. And it followed the standard that the Obama administration had, was that most people should be considered employees under the Fair Labor Standards Act. When you're considered an employee under the Fair Labor Standards Act, you're eligible for workplace safety, for benefits, for overtime if you're not exempt. There are a wide variety of benefits to being considered an employee that are not offered to employees who are considered contractors. That was the standard that Obama put in place. It was an interpretation. It was guideline for how to determine whether somebody is an independent contractor. That's been rescinded. So now we're going back to the old standard, which is simply whether or not they have independent control over their work. I should also say that the Department of Labor and the IRS both maintain a standard for what's considered an independent contractor, because the IRS sees this with all of the 1099s. So they're interested in seeing whether these are bona fide independent contractors versus employees. So that's going back to the old control test, which is more favorable to employers to be able to use independent contractors. There's another piece of this, which is that the Obama administration was looking at whether or not franchise organizations or affiliated companies that have some sort of relationship with one another are one employer for the sake of having an employee work multiple hours and multiple times with this employer. So for example, if I have a franchise, I'm a franchise owner and I have a Wendy's and a McDonald's, and they're all under my franchise. They're all part of my one company. If I've got a worker who works 25 hours for me at one place and 25 hours for me at another place, they're not eligible for overtime anywhere. But if we look at that as one employer, then they would be eligible for 10 hours of overtime at time and a half. So again, this was a big step forward for the Obama administration to put that out there. The new Acosta administration, Trump administration, has stepped that back and said, no, we are reversing the guidance put forward on joint employment. So these are pro-business rollbacks of regulations that we're just beginning to see this month take place. Charlotte, any thoughts on that?
Yeah, I think it's important when we look at the administrative interpretations that come out. It's important to remember that administrative interpretations are not the law. They're merely interpretations of the law. So in this back and forth of what's an independent contractor, what's a joint employer, no law has changed since the administration changed from Obama to Trump. It's merely the Department of Labor's current interpretation of those laws. And where that matters is that, interpretation aside, it doesn't change an employer's legal right to get it right. In fact, sometimes administrative interpretations make it more difficult, because when you start going out there and Googling stuff and you've got all this conflicting information, and sometimes it's more generous to you, sometimes it's more generous to the employee, and it can get difficult. One of the things that Acosta has said that he would like to do is, a long time ago, some people may remember, the Department of Labor used to, instead of doing administrative interpretations, they would create what were called opinion letters. So employers could actually submit their issue to the Department of Labor, or if the Department of Labor was getting a lot of feedback on a particular issue, they could issue an opinion letter on that issue. And again, it wasn't law, but it really took everyday situations that business owners are actually dealing with and helped guide them to what the right track is. The Obama administration did away with opinion letters and introduced the administrative interpretation. Acosta has said he would like to do away with administrative interpretations and go back to opinion letters, which he views to be a little bit more friendly and useful than just constantly swinging back and forth on how much we want to enforce a particular standard.
Right. Right, and of course they're the courts, because you can have these opinion letters, you can have these guidelines that are put forward by the administration, but ultimately it's the courts that are determining whether or not that's the appropriate interpretation of the original law. So, you know, there's always this look back to the original law. So interesting. We'll see what happens with that. For independent contractors and for joint employers, if you want to check out the current standard for independent contractors, it's the DOL fact sheet number 13. And for joint employment, it's the DOL fact sheet number 35. So some resources for you to take a look at.
And of course, we're always happy to help guide through those.
Yes, it's our favorite thing to do. It's what we do. One other thing coming out of the federal government, I'm not going to spend a lot of time on this, but OSHA has had some movement. There have been some changes that have taken place since the Trump administration has taken over. The Volks rule was a rule on record keeping within OSHA, and it had stipulated in the past that that all companies need to keep a record of up for 5 years of accidents and injuries that need to be reported by to OSHA. But prior to that, if you had the OSHA only had a 6-month window with which to issue a penalty. So although you had to report it and maintain it for 5 years, you were only really liable for that illness or injury from a penalty perspective for 6 months. The Volks rule extended that to 5 years and 6 months. So it extended greatly the amount of time that an employer is liable for an illness or injury or accident on the job. That's been rescinded, so now you still have to keep the record keeping for 5 years, but we're going back to the 6-month window where penalties could be applied. So that overturned that record keeping provision. There was also an electronic submission of incident data that was going to go live at the beginning of this year that got pushed back to June, then it got pushed back to July, and now it's on hold. We don't know when it's going to come out. The idea being that you're already keeping these records of accidents and illnesses. They want them reported on to the federal level. So you can kind of expect that that's probably going to take place at some point in time, but for right now it's completely on hold. But there was one little provision within this electronic submission regulation, and that was that if you as an employer were automatically drug testing an injured or ill employee automatically upon the occurrence of an incident, that has the potential to dampen somebody's likelihood to report an illness or injury if they worry about being drug tested. So the automatic or mandatory drug testing was concerning employees enough that the concern was that they weren't reporting bona fide accidents, workplace accidents. So the electronic submission form basically said that you need to exert discretion before you drug test somebody when they've reported an illness or an injury. So for example, if I'm a truck driver and I'm driving erratically and crash into a pole, you might suspect that maybe there's a substance involved and drug testing would be warranted. However, if I'm just walking down a hallway and rub my hand against the wall and cut myself on something sharp, there's no reason to suspect that I was under any substance at the time. It would be fairly unreasonable to drug test me when all I've done is rubbed up against a wall and cut my hand. So this provision, as far as we can tell, as far as we know, is still there. So if you as an employer are mandatorily testing for drugs when anybody initiates an illness or an accident or an injury, you need to be looking at that very carefully, and you need to be exerting discretion. You need to call us or call whomever you would be using for reporting that. But this provision, although the electronic submission has been delayed, this provision of mandatory drug testing is still on the books and is still enforceable and has been enforceable since January. Charlotte, any thoughts on that?
Just a wise crack that it may not be enforced, and that's the challenge with so many of these things. They're on the books and enforceable, but that doesn't mean that enforcing them is a priority of the current administration. So you get in that catch-22, do I take my chances or not? So right. That's where we talk about risk and reward and pros and cons of of going one route versus the other.
Yeah, and I think on this you just need to be a little bit careful though, because I think it's unlikely that they're going to be hiring a lot of new investigators to come in and harass workplaces, but the accessibility of a worker to report one of these claims is really easy. And so getting reported is a pretty easy thing to have happen. In fact, I was dealing with a client just this morning who had both OSHA and the EPA showing up at their doorstep because a disgruntled employee had filed a report, and all of a sudden now they've got issues. So from that perspective, I would recommend that you at least pay attention to this and not do mandatory drug testing unless you've really sort of taken a look at it and are sure you're comfortable with the decisions that you're making.
Mm-hmm. Agreed.
So we're also reading the tea leaves in terms of what the administration wants to do in the budget, the budget that was released for 2018 had a number of initiatives that do apply within the workforce, within the workplace. What I will say is that all experts basically say that what's contained within a presidential budget is basically a wish list. Very rarely does this end up the way it shows up in the budget. Does this actually end up real life, lifetime existing? That said, I think it's a good indication for us of whether or not there really is an intent to follow up on some of these campaign promises, as we heard in the fall. And the first is the 6-week paid maternity-paternity leave. This is a federal benefit that they're putting out there. It would be funded and operated actually through the state-based unemployment insurance system. Again, it's a broad stroke. We don't really know what this would look like. There's some concerns among those within the states that this is a bad idea because these state unemployment insurance programs are largely underfunded, and the requirement to initiate this new program and operate this new program out of that system would in itself require some additional resources for a state to take on, and there's a concern that that would cause a pressure to increase state payroll taxes. So even though it's sort of pushed to the states, it's still sort of out there and not a lot of details, but this was a prominent campaign promise that we heard from the Trump administration. So I think you can expect that this will be an initiative that they try to work on. If not within this year, this will probably continue to be on those social cause initiatives that they're pursuing. We've also saw in his budget an initiative to merge the Equal Employment Opportunity Commission and the Office of Federal Contract Compliance Programs. I didn't say that correctly, but both of these organizations, EEOC is an independent entity within the federal government, OFCCP is within the Department of Labor. They both have some role in managing and enforcing non-discrimination laws. OFCCP exclusively for federal contractors, and EEOC for private employers. But it's a little odd. It's a little, you could think that there's some efficiencies there, but they also are very different constituencies that they report to. So it's an interesting question. I don't really know what that looks like. They say it would be enforced by 2018. We'll see. Not a lot has been said about this, but it did appear in the budget. Yeah.
One of the things that I have found interesting about this, even though there's not a lot out there about it yet, is this is one of those areas that there's getting a lot of bipartisan support against doing this. Both sides of the aisle are against this because it would essentially create a mega equal employment opportunity commission with just insane overreach into private employment.
Overreach potential, yeah.
Yeah, and particularly when the OFCCP is designed to oversee affirmative action and compliance with federal contracts, where the EEOC is an entity that's meant to address discrimination and a vehicle for employees to file claims of discrimination, et cetera. So so the muddying of the waters of those two together, it goes way beyond just combining what feel like a similar entity. So I'd be surprised if this one went through because it's got an unusual amount of bipartisan support against it.
And some of the other support against it is that they worry that this is a sort of a covert way to gut enforcement of discrimination, you know, in the workplace. So you've got those who are worried about the governmental overreach, and then they're worried about the opposite of the governmental overreach, but they're worried about sort of the enforcement going away altogether. So yeah,
and
pretty broad support against it.
Purely from a political perspective, can you imagine being an elected official who, even though this would not do away with the EEOC, the perception would be that the EEOC kind of got squashed a little bit. So can you imagine being an elected official that looked like you tried to squash attempts for to protect non-discrimination laws?
Yep. So again, interesting debate. You can see what Charlotte and I do all day long. We just sit here and debate these sort of things. Also in the budget is a 20% reduction in the Department of Labor's budget altogether. And I think you can imagine that this co-joining of EEOC and OFCCP is part of that initiative. But also I think they're planning on not having as many regulators, not having as much enforcement. So overall, a pretty hefty cut in the Department of Labor. 6% cut for the National Labor Relations Board. And here's the big whopper: mandatory EVerify for all employers nationwide. So this was proposed as a campaign issue, a huge issue for employers nationwide. What does this mean? So currently, I'm trying to get my slide to go forward. There we go. Currently, there's no mandatory use federally for EVerify. It's a voluntary program to help employers manage their hiring of legal workers in the United States. And a lot of people sort of confuse this with having to fill out the I-9 form. A lot of the data that is collected on the I-9 form is what's used as the basis for evaluating on the EVerify system whether or not somebody is legal to work.
And to clarify, Claude, just to clarify, it's voluntary except for certain federal contracts. In federal contracts, it's not voluntary.
Correct. So, and in some states, it's not voluntary. In some states, it's mandatory of all government and private employers. But in most states, it's relatively, and you can see from this chart right here, everything that's in orange does not have a mandatory EVerify. Everything that's dark blue is mandatory EVerify. And then you've got governmental contracts, federal contracts, certain agencies that are, certain types of companies being required to do this. This would be a huge change. Everybody would have to run their potential employees through a mandatory EVerify. We have clients that are on this call for whom that would be a big challenge given the nature of their workforce. And I think administratively, there's a big piece to this as well. I know a lot of employers are not happy about this. A lot of clients that we work with, if they've got a certain federal contract, they will hire a certain sect of people to work on that federal contract, and they will apply the EVerify for those workers, but not for their other workers. So, this is not a slam dunk, and I think there's going to be a lot of opposition to this from employers, let alone immigration rights activists. But I think employers are going to see this as a pretty tough nut. So what do you think about that, Charlotte? Do you have any thoughts on that?
Because one of the questions that I get asked often for those who aren't sure if EVerify applies to them is this is not a replacement of your current I-9 process. This is an online process in addition to the I-9. So, this is a matter of collecting that data on the I-9 and then going through the EVerify process to compare information with the Social Security Administration, et cetera, to confirm that the person is eligible to work in the United States. The process of enrolling and using the system is pretty cumbersome, right down to you are required to take a tutorial and a test you have to pass the test before you can use the system. So the process is cumbersome. It's not that the I-9 is fun either, but the EVerify definitely ratchets it up quite a bit over the administrative burden that verifying authorization to work in the United States creates.
Yeah. So, so have fun with that. We'll keep an eye on that. We'll let you know if that rolls out. But again, not a little and not necessarily a pro-business initiative. So we'll see what how this pans out. All right. So now we want to go pretty quickly through the state actions, things that we want you to be aware of, that we want you to know are sort of rolling down the path. The first is the minimum wage. We're seeing all across the United States minimum wages. I think 19 minimum wage increases went in on the state level alone in January. And then on top of that, we've got municipal governments, city governments, county governments putting in their own minimum wage, whether that's just for county workers or whether that's for all private employers. You know, it's a myriad, it's a patchwork quilt of minimum wage. And if you have the type of workforce, for example, cleaners or janitors or on-call employees or people that go to a workplace and work in that workplace, you have to apply that minimum wage in that workplace, in that jurisdiction. Like, for example, in the New York metropolitan area, in the California, you know, the San Francisco Bay area, in the Washington, D.C. area, you have all of these different minimum wage levels that you have to comply with if your employees are working there. So you need to know your geographic footprint and keep an eye on the minimum wages of each of those locations. We also have equal pay. Charlotte, jump in if you have anything you want to add on any of these.
Okay.
We also have equal pay regulations that are going in place. We're just beginning to see these come out, but they definitely are a big trend. And basically what equal pay is, it basically says you cannot ask the prior salary history of a candidate for employment either as you're interviewing or in the offer. And the rationale behind that is that if you have a section of people who are historically suppressed in terms of their wages, women, minorities, and you base their future wages on their current wages, they will always retain that inequitable level compared to their peers. So what the premise of these regulations and laws are that you base the pay based on the requirements of the job, not on the prior salary history of the candidate that you place into that job. And that in itself helps to eliminate the pay gap or the inequitable pay among workers. Again, we're seeing this in a lot of locations, California, Massachusetts, Pennsylvania, New York City. So this is a growing trend. You know, these things sort of start out there and then they spread along the way. But a fairly benign thing that does have some consequences in terms of pay going forward. Moving on to parental leave and paid sick leave. Again, we are seeing a lot of this. Not so much states, but localities are passing regulations that have some form of paid sick leave, paid paternity leave, and requiring that employers do this and set up some sort of a fund. It tends to look at what I've seen so far. It tends to mirror the disability programs, the state mandated disability programs where those exist. So it is a growing trend, and now we're seeing the president mirroring some of that initiative with his federal parental leave.
And Claudia, for the paid sick leave in particular, a lot of organizations, typically the paid sick leave outside of the parental leave, a lot of times the paid sick leave, employers who already offer vacation sick, PTO, they may already be offering more sick leave than these local sick leave laws are requiring. But one of the trends that I've noticed with these paid sick leave laws is that the eligibility for the benefit of paid sick leave, and it's not always a lot. It might be a few hours a year, but that benefit has to extend to not just necessarily our full-time employees. Some say that it extends to all employees. Some say that any, if you work a certain number of hours. So that's where even if you have paid sick leave in your locale and you feel like, well, I already offer more than the sick leave law, look at who's eligible for sick leave, because it's possible that it may be your part-timers, and it's possible that you have to start accruing that from day one, where maybe your current policy, you don't start accruing until after 90 days or 6 months or a year. So it's the devil in the details kind of thing there.
You know where to find us.
Yep.
Ban the box. All right, this has been around for a while. This is everywhere. The localities have absolutely taken over this. Very simple. Basically, it says that you need to eliminate on your employment application the box that says, have you ever been convicted of a felony or of a crime? Sometimes they say misdemeanors. Have you ever been, are you a convicted felon? Whatever. What they're trying to do is basically create the barriers to employment for employees or potential employees who, despite their prior incarceration and subsequent rehabilitation, would be qualified for the job but never get that far because they check that box and then they never make it farther in the hiring process. So basically these are regulations that are, again, it's a grassroots campaign. It's all over the country. And it basically says you can't ask that question until later on in your hiring process. It's a good idea anyway.
Yeah, it doesn't forbid the question. It just can't be asked on the application, because presumably if you're continuing to talk to them, now you're interested in them as a candidate. And then if there is a criminal background there that has to be considered, then you would weigh that very carefully based on the individual, the job, the nature of the conviction, how long ago it was, a whole number of things that you would weigh and make a very individual analysis, getting away from the previous method of just literally they mark yes on the box, pitch it in the trash. That's what we're trying to get here.
Right. And again, as consultants, we think it's a good idea. Push it. Why would you fail to look at a qualified candidate just because they have some form of criminal history that may or may not be relevant at all to what your job is? Give that candidate a chance before you start weighing those other qualifications. In some instances, we recommend that you don't even check on this until after a conditional offer of employment. Offer the employment saying, yet we will look at your criminal history before making a final determination. So as far along in the process as you can do it, the better for everybody. Scheduling predictability, we see this in basically cities, Seattle, San Francisco, New York City, where they're saying that if you have these sort of, typically it's restaurant, typically it's the service sector, if you have last minute scheduling, you need to give workers some sort of predictability. Some of them give them a week, some of them give them 2 weeks, but you need to give them some predictability as to what their schedule is going to be, because a lot of these types of employees have multiple jobs. And if they're trying to work on a last minute schedule, it makes it very hard for them to maintain multiple jobs. What they tend to say is that if you give them less than a week or 2 weeks notice, you need to pay them some sort of a consideration or some sort of a benefit to that. They vary, of course, because all these things are local and they do vary. But again, another trend that's out there, keep an eye out on it. I don't know that this is going to be the biggest thing that comes down the pike, but it certainly is something that's been making the blogosphere, next big thing to hit HR. The last thing I have on this list is concealed carry. We need to be mindful right now, particularly in southern and western states. A lot of employers put in their policy that they're a gun-free zone and that there are no weapons allowed on their premises, not in the office, not in their cars, not on the driveway. There have been a lot of laws that have been passed within the last 5 years that give gun owners who have licenses to carry concealed weapons the right to keep them locked in their cars. So know that this is also going out there. You should keep an eye on those laws as they exist and make sure that your handbooks and policies and procedures are consistent. Some of them say that if you don't prominently place a notice that say this is a gun-free zone, that an individual worker with a concealed carry permit could bring that weapon with him or her into the workplace and work with a concealed weapon. So the nature of these laws, again, vary, but if you do have a gun-free workplace and want to maintain that, you need to take a look at these regulations, these laws that are coming out, again, state and local, to make sure that you're compliant.
And Claudia, for a lot of handbooks that I look at that have been prepared by previous people in the past, previous organizations, or maybe you've downloaded a generic handbook from online, just because you don't see anything about weapons in your table of contents, go to your workplace violence policy. A lot of time language around weapons is buried in a violence policy. So don't assume that you don't have something in your handbook that may go against state law just because you don't see a subject header that says weapons.
And just a note, we always say this, please don't download your handbook off of the internet, because these laws, you need to know that these laws vary by locality. It matters what jurisdictions you're in. It matters how many employees you have. It matters how many states you're in. It matters what industry you're in. It matters whether you have federal contracts or not. There's so many things that affect this. And what I see employers doing more than not is they'll download some book, some handbook from some like hotshot law firm, and they've got 20 employees and the law firm has 300, and they obligate themselves to things like the Family Medical Leave Act, or, you know, you name it, the Americans, well, you name it, healthcare. So just be mindful. If you did that, you might want to have somebody take a look at it, because these things are so specific and you don't want to obligate yourself to something you're not required to be compliant with. And likewise, you don't want to leave yourself wide open where you could button it up pretty easily. One last point before we take our questions, and that is that despite all these state actions, we are seeing states getting ahead of them now and preempting local workplace ordinances and laws and regulations. So basically, there are a number of states now who have gone out and said, look, you cannot have a local minimum wage that preempts the state minimum wage. You cannot have a law that talks about the conditions of work and benefits and compensation and breaks and leave and rest periods and all of these things, if it differs from state law. And the most sort of politically sensitive one is the anti-bias protections. This is really the transgender workplace laws. And so many states have said, you cannot get ahead of us on this, because it creates such a difficult working environment for companies who are working within a state or within multiple locations within that state, or God forbid, multiple states. So as much as we're seeing a lot of state action going on, we're beginning to see states take a sort of a defensive action and saying, we're going to put the kibosh on this, so that if we're going to put in a workplace regulation or a requirement, it's got to be on the state level. It cannot be on the municipal level. So that's a prominent trend that we're seeing now as a counterbalance to some of the other trends. So that's pretty much what we wanted to share with you. I don't know, Charlotte, if I forgot anything, or if we're ready to kick it off to Megan and see if there are any questions for us.
No, let's kick it to Megan.
Megan?
Great. We did have a couple of questions come through, so we'll jump right in. The first one is, how does the what's going on with individual healthcare insurance affect employers' group insurance?
Okay, so what I'm going to say is I have no idea. You know, currently nothing has changed, right? Because the repeal as it went through hasn't passed. So the laws of the ACA are still in effect, because it has not. It is, as a piece of legislation, it has not passed the appropriate bodies of the House. So as the individual market was last year, currently it is again today. But again, all of these things depend if you're in a state that has a state pool, or if you're part of the federal pool, the income of that individual. So it's really hard for us to answer an individual question like that without knowing. There's no general answer I can say to you. What I can say is, as of right now, nothing has changed. It's the same as it's been the last couple of years.
Okay. If businesses want to keep tabs on potential impacts of the ACA and other legislation, what online sites or news sites would you recommend to track, and how often?
That's a very good question. I mean, I think the sites that I like to go to are like the Chamber of Commerce, the NFIB, National Federation of Independent Businesses, local or state manufacturing associations. They tend to have really good resources. They tend to have very strong lobbying arms. Also, if you're within a particular industry, many of the industries, for example, the building service contractors industry, the association itself keeps track of a lot of those things and has a very robust lobbying arm as well. So you know, I think it's just knowing the right sources that are within your space and just keeping tabs on them. If you want to contact us offline for some of the resources, I don't know what industry this question comes from, but we might be able to provide a little bit more guidance. Charlotte, do you have any other thoughts on that?
Also, there's a lot of information if you're just looking for general employment-related stuff. SHRM, Society of Human Resource Management, shrm.org. A lot of their information you have to be a member, but a lot of information you don't have to be a member. And they keep their site very, very updated and very current. So there's a lot of good information to be had there if you want to Google a certain topic.
Mm-hmm. And we maintain, we pay into a resource that keeps track of all of the legislation on the state, federal, and local level. So chances are, if you're concerned about something and you can't find it in a Google search, you can't find it in any of the other sources, contact us, because we do, and this is maintained by attorneys. It's pretty much real time. So that's what we use for a lot of the work we do around compliance when we need to figure out, all right, what does Dubuque have in terms of this particular policy issue? So we might also have some of those resources available to you.
New York is implementing a paid family leave. Do you have any insight into that?
Well, I do know that they are, and I do know that New York City is sort of the launch on that. The leave benefit is pretty comparable to the disability benefit, so it's not a full income replacement benefit like you would normally see. It's a fairly minimum benefit that's available, but again, it's available to all employers within that geography. So I kind of know that much about it. I haven't gotten too far into it. Charlotte, do you have any more details on that?
I believe I actually have a flick on it. So if the person who sent that question is on the line and wants to drop an email to that email on the screen, contact@affinityhrgroup.com, I can pull that flick, a little factoid on it.
A fact sheet. We have a fact sheet on it. Great. Yeah. Well, there you go. See, I told you, she knows everything.
That's what I do. I find the information.
I love it. And I find you. That's how that works. What else we got?
Okay. Well, that's all the questions that came through our question system. So do either of you ladies want to close out with any final thoughts?
Sure, I'd be happy to. Well, first of all, Charlotte, why don't I let you close out your thoughts, and then I'll close out my thoughts. How about that?
No, my thoughts are closed. I think, I mean, we're essentially trying to read the tea leaves here, and we've got some good ideas of where it's going, but I think what today shows is the patchwork of activity that's out there when you layer federal efforts on state efforts, on local efforts. It just shows how broad it's gotten, and how there used to be a single minimum wage, and now states are going. So I think it's a sign of things to come, that no longer the question is how many employees do you have. It's now, okay, what state are you in? Okay, well, what city are you in? And a more thoughtful analysis of what laws are out there and how they really pertain to an individual company.
You know, I had a really interesting conversation with somebody who a business owner who I've known for years and years and years. He is a very, very strong partisan Republican, very loyal partisan Republican, who called me and said, you know, I got to tell you, I would rather they pass some of these things on the federal level because I'm trying to comply. He's in 14 states. So, you know, really struggling with trying to keep up on all this stuff. So, you know, that the grass is always greener. But anyway, yes. So we hope you've left you with some information, some things to keep an eye on. We're here if you have any questions, and I just want to reiterate that if you have any follow-up questions, we're offering this consultation, and we're just a resource to you. We may be a resource to your association, but even if we're not, we're always here. We're always available. Our website is on the screen, affinityhrgroup.com. Contact us at contact@affinityhrgroup. We're here to answer any of your questions. If you would like this slide deck, I would be happy to put that forward, and we will also have a recording of this session that we will put on our YouTube slide, our YouTube page, and again, that's accessed through Affinity HR Group. Thank you so much for your time and for spending some minutes with us on this lovely summer Tuesday, and hope you're all well, and do give us a call if you need anything. And thank you so much, Megan. We appreciate all of your help.
Ladies and gentlemen, this concludes our virtual seminar for today. I'd like to extend a special thank you to Claudia for presenting today's session and Charlotte for contributing to the conversation. Thank you for joining. I hope to see you on the line for another joint webinar soon. Have a nice afternoon, everyone.